between these two panels. So you're all bound to stay inside this room without any coffee for just one more hour before we break for cocktails and dinner. But with that, I would like to call upon our last panel of the day today. So I'm going to chastise Nidhi on the mic and tell her to release our panelists and let them come on the stage. So absolutely. So we'll start our next session, which is the panel discussion on the role of general counsel in running efficient and effective arbitration proceedings. And I'd like to call the panelists on the stage. The panel will be moderated by Mr. Rajendra Barot, who's a partner at AZB and Partners here in Mumbai. Welcome, Rajendra. We have Faraz Sagar. Oh, you're in his place. Okay. We also have Mr. Nitesh Jain, a partner at Trilegal. Ms. Nidhi Parekh, who's the head legal SR. And Ms. Zarina Chinoy, General Counsel, EPC Division, Shapurji Palanji Group. So thank you and welcome to all our panelists.
Hello. Good evening, everyone. Thank you very much for organizing this panel, which is going to throw up a lot of interesting questions. And I guess questions that relate to what happens when the rubber hits the road. So we've heard about arbitration clauses and we've heard about implementing the arbitration clauses. But the question is it really effective and is it really efficient? So we thought what we would do is we would present views by a mixed panel. So what I'm going to do is I'm going to have a brief introduction of the panel. So we've got Zarina here, who is the GC in Engineering, Procurement and Construction Division of Shapurji Palanji Group. She's a solicitor and she has over 19 years of experience. And her specialization is negotiations relating to construction and finance contracts, as well as dispute resolution, including ICC arbitrations. Sitting next to me is Nidhi. She is the head of legal of SR and has over 16 years of experience across multiple sectors, including oil and gas, infrastructure, mines and minerals, petrochemicals. So apart from the two GCs, we've got two practitioners. So we've got Ankoosh Mehta, who's a senior partner from Cyril Amarchand Mangaldas. He's also a solicitor since 2002, has over 18 years of experience in advisory and litigation matters. And he does a lot of commercial disputes and white-collar crime advisory. And then we've got Nitesh Jain, who's a partner at Trilegal, over 16 years of experience litigating before Indian courts, including Supreme Court, High Courts, trial courts, tribunals, regulatory commissions. Nitesh does a lot of international and domestic commercial arbitration, also does white-collar crimes and insolvency matters advisory. So to start, a very brief introduction to what we propose to do. What we thought was we'll break this up into 4 parts. And I think it needs no introduction, an arbitration clause. Because if you are doing a contract in India, and unless it's one of those issues which cannot be arbitrated, I think an arbitration clause is a given. So what would you typically look for in an arbitration clause? And let's start first with the industry. So
You want to go first, Nidhi? Good evening, everyone, once again, and thanks. I'm happy to share this panel with all my esteemed colleagues here. I hope I'm audible. Sure. Thank you. So, as we spoke in the morning as well, and we discussed, arbitration clause is, is a no-brainer. You cannot not have an arbitration clause in today's day and age for various reasons, not only from the perspective of the enforcement, but also, cost-effective, time-effective. And I speak a lot from the business industry because I work in-house. While we, of course, want the matters in our favor and we want to win each and every litigation that's out there or arbitration that's out there, but you also have to ensure that it's cost effective, and that's one major concern a lot of business teams and promoters keep in mind, and the management keeps in mind as well. When it comes to arbitration clause, so of course, we established that we need the arbitration clause. With the evolution and the amendments, we see, as what we saw in Anupam Mittal and Westbridge case, that now the arbitration agreement needs to have a seat. I'm not, as I discussed in the morning, I would not be in favor of that. And as I said, it should be implied that if the seat of, if the seat or the law for arbitration agreement is not mentioned, it must be implied that what is there in the master agreement applies here as well in the entire, for the arbitration agreement as well. Apart from that, I have, as a standard practice been doing over the last couple of years is ensuring that mediation has been a part of my, dispute resolution clause. So my clause generally reads that, the parties will first mediate, failing which, if in 90 days they can't come to a resolution, the matter would be referred to arbitration. Now, depending upon the stakes involved, the other side, the nature of the claims, etc., you decide if you want one arbitrator, which is the rules you want to take into consideration: domestic, institutionalized, which one, and your claims decide which and how mammoth of a task do you want this arbitration to be. If it can be resolved through mediation, I think that's the first resort you should go to, because from an industry that I come from, for example, from oil field industry, it's a very niche industry. So everybody knows everybody. Every crew member who's working on my rig will have at some point worked on your rig and the other rig and XYZ, every possible rig. So the information floats very quickly, and you will always land up doing business with the same people over and again over the couple of years. So to ensure that relations stay intact, your business relationships stay intact, you might want to consider mediation over arbitration. The other important points in the clause should be, of course, the venue, the seat, the language, and as COVID has taught all of us, as far as possible, to keep it online, for administrative work and for preliminary meetings. Maybe something like cross-examinations, etc., and hearings can be taken offline, but everything else otherwise can be considered to be kept online as well. So that's how I would go about drafting my arbitration clause.
No, thanks. So I think and this obviously is when you have the luxury of choice, because there may be occasions where you do not have the luxury of choice. It depends on your counterparty. So, Zarina, what's your take on how much of flexibility have you seen when it comes to an arbitration clause, and what do you think are must-haves? Because I'm sure there are occasions when you're given an option of saying yes or yes.
Yes. Lots of choices sometimes. I think the question merits me breaking it up into two parts. Am I looking at a private party in front of me? Am I looking at a government or an institution or a PSU in front of me? Depending on that, my arbitration clause itself will change. If it's a private party, like Nidhi said, everything can be discussed. Everything is open. Everything has a negotiation point. In fact, there are gives and takes in each case. There are some things that they may want, there's some things that I may want, and there is a good enough barter system in that respect. So that works. But in cases where I am looking at a government, a PSU, or a state entity, then the arbitration clause may in fact be fixed in stone sometimes. They will not deviate on anything. There are times they will not deviate. Of course, seat venue, I'm sure you've all seen, they are more comfortable in jurisdictions they believe that they can, or they have some sort of control or at least an image, a perception in it. None of those then will change. But in cases like in private parties, every single thing in that arbitration clause has a time and a cost effect. So you have to be very calculative in what you are going to put down. It's not that I'm generally comfortable as a GC with a seat in Delhi. No, it doesn't work like that. It depends on also the kind of work that is going to be envisaged in that contract, the kind of disputes that are envisaged. If the disputes are going to be high value, if it's a construction dispute, it's going to be high value, then you are going to look at a seat which is going to be easily accessible. Lawyers, the teams, the expert, everything around that has to be structured initially itself in order for you to prepare for the worst case scenarios. And we lawyers always prepare for the worst case scenarios. That is why we have arbitration clauses in the first place. So given that, we take a great deal of effort in drafting these clauses. We take a great deal of time. There's a lot of negotiation and a lot of thought process that goes into each part of these clauses. And we do sometimes look at arbitration. We do break it up in the sense that if there's a certain quantum of dispute, if it's below a certain dollar value or above a certain dollar value, we'll say this kind of arbitrator, this kind of forum, and we will try to break it up. Yes, it makes it more complex, but at least there are directions. There's no second guessing in that case. So when the dispute comes, we open it up. We've seen that these are the challenges. This is where we're supposed to go. Point A says one arbitrator or three arbitrators. The forum is discussed. The parties are, the dispute, the kind of disputes are there. If it's all written in stone, at least we have a guideline to start with there.
No, thanks, Zarina. So I think the learning is an arbitration clause gets tested when things are not hunky-dory. And so therefore, what are the standard mistakes that we see, or what would you want to avoid? I mean, the saying is, the simpler your arbitration clause, the better it is. But, I mean, Nitesh, in your experience, where have you seen hurdles come up when, parties are fighting and the arbitration clause is what everyone resorts to?
So, the arbitration clause, I mean, of course, we are saying arbitration clause, it's called as the midnight clause, right? This is the last clause at 11:50, somebody will call, that we have to sign it by 12 o'clock. Please bless this clause. And then we litigators will ask questions, right? And we'll ask few basic questions as to who are the parties, nationality, where are the companies incorporated. They're like, no, please don't ask all these questions. Just bless this, okay? And then we'll be like, okay, does it say any dispute arising out of or in connection with? They're like, yeah, this is there. So which means it's very, very broad. I had a dispute last week where the arbitration clause didn't start with any dispute arising out of, right? So the dispute was whether your arbitration clause is narrow or wide, right? The other issue was whether your arbitration clause includes dispute in relation to management or not, right? Courtesy, Mr. Barot, who's sitting here. I again had an argument to say that management word, forget about the arbitration clause, it's there somewhere else in the shareholders agreement and therefore you can incorporate, right? Because luckily that clause said any dispute in relation to anything that's set out in this agreement. So, again, you have to have some struggle. Other common mistakes and where we struggle is whether it says seat, it says place, it says venue, right? Then you keep fighting for it, right? Do you have an exclusive court clause, whether it is subject to arbitration or it's the other way? Again, there is a dispute there, right? Whether it's a unilateral appointment or it is that the parties have decided whether it will be sole or three arbitrators. Again, there is a dispute there, right? A lot of times, there is a thought that goes into whether it has to be institution or ad hoc, right? And nowadays, institution, because you have the option of emergency arbitration, right? Within 14 days, we have actually seen results. Within 14 days, it's actually decided. But then the other issue is, if you're opting for institution and emergency, whether are you doing it in India or outside India? Outside India, whether emergency arbitration order, whether it's an order or an award, whether it's enforceable or not, and then you again file Section 9, again, there are a lot of disputes, right? I think we can do the entire ADR week only on arbitration midnight clause, right? It has that much of capacity in terms of disputes and the issues involved, right? The other few issues is when you have multiple agreements, whether do you have consolidation liberty or not, and what about joinder? If you have an institution rules, of course, it will cover everything, right? What about confidentiality? Do you want to agree, not agree, whether it's provided under the Act, not there in the Act? So these are, few components where individually you can have various disputes, and therefore you certainly need to invest a lot of time, right, in terms of finalizing what exactly that you're looking. And this, I think, comes more by experience. So I think that's where the role of GC, which is, I think, the right identified topic by MCIA on this, right, which is, I think, in terms of how the experience of GC, in terms of the sector, industry, the counterparty, right, if they can give us the right information, their experience, I think that's where the GCs and the lawyers can sit together and come up with a good solution, and to minimize to whatever extent at least we can when it comes to arbitration dispute.
So Ankush, if you could just add your thoughts, and again, I have a view on whether it's a midnight clause anymore, because I think life has moved on. People have learned that, while experience is the best teacher, tuition fees could be too high. So, I don't know, Ankush, if you have a view.
No, I do. Thanks. No, I've heard the panel very closely. I'm not sure if, we are looking at arbitration as a complete solution to all the issues, right? We're all litigation lawyers in some form. We've experienced innumerable hurdles in some form when it comes to implementing or actioning the arbitration clause. The question is, I'm going to try and give a different perspective. The question is it the right approach for the company or the client as a whole that you necessarily must have the arbitration clause? Yes, we all discuss there are commercial contracts and they should have. But I was just discussing in the pre-panel sort of conversation that we all talk about arbitration in a commercial setup. What about arbitration in a non-commercial setup, in a family dispute, etc.? What about arbitration or an alternative approach, let's say mediation, let's say no arbitration, let's say courts, where you are in continuous engagement with the counterparty over different contracts, right? You will initiate an arbitration in one, what happens? Is there an ability to continue to work with the counterparty again and again? Third, I think the focus on mediation should not be undermined. I know we are not undermining it. But especially when contracts, at least in my own experience, especially when contracts are long drawn out, right? If you have parties in between firing off section 9s, etc., it impacts the overall ability for the contract to get concluded or achieved. So, yes, I mean, it definitely has its benefits, no doubt about it. And, in terms of where it began and where we are today, we all know how courts in India, at least in a larger sense, are lesser keen to intervene in arbitral awards. But I just want to leave my take by saying that, look, I'm not sure, other than a midnight clause, 4 a.m. clause, it's been given different names. I'm only not sure whether it's a one formula fits all. I'll just leave it with that.
No, thanks. So I think to kind of summarize, I have seen the approach to an arbitration clause evolve in last 20-25 years. I've seen that suddenly an arbitration clause is something which does get a lot more attention than what it used to. People are mindful that the reason why you want to go to arbitration is because you don't want to burden a court which is already burdened. And even when it comes to an interpretation, if there is room for interpretation, and remember, as they say, copper wire was invented when two lawyers were fighting over a penny. So if there is space for interpretation, there's bound to be delay. We've seen, I remember there was a time when there was a huge question mark on fraud and arbitrability. And respondents used to come and raise fraud as an answer to say this issue cannot be arbitrated because they've said fraud. And the claimant will say, I've not said fraud, I've said misrepresentation. And that was interpreted by courts. It took about 10 years. So the elephant walks, it can't dance because it's just the size of India. And I think my takeaway is we are much more proactive now in dealing with arbitration clauses. To put a challenge for the transcribers, हजारों ख्वाहिश है ऐसी कि हर ख्वाहिश पे दम निकले. बहुत निकले मेरे अरमान, लेकिन फिर भी कम निकले. So I'm sure all of us will keep evolving. So now let's go to the second bucket. The second bucket is when there is a dispute. So obviously when there is a dispute, it's the in-house counsel who would come to know about it first. But let me now try and turn the question on its head. So let's start with you, Ankush. On when a client would approach you, what have you seen as a standard process that a client would expect? Obviously, bearing in mind that nobody likes litigation, but we are necessary evils.
So, I think of late we'll agree with one thing that the kind of disputes that are emerging, it's not always, and with due respect to my colleagues and actually friends, it's not always the GC who's approaching us, right? There are different types of disputes, for example, technology. Very often you'll have somebody else than the GC, or along with the GC, there is somebody else who's giving you instructions. Other than that, I think client as a whole is extremely well informed, extremely clear on what he or the client needs to achieve, and extremely clear in terms of practicalities. I think today we don't have to, have the standard lines of, I mean, every client, and I know it's unsaid, but I will still say it. Every client will ask you what's the percentage of success, and our standard answer is we don't give percentages. But I think other than that, the client also knows the answer. So I will just add a couple of points here to say that, because the client is aware and focused, and in fact that penetrative enough to know that really who's the best person for the job, sitting in which law firm, counsel, etc. This kind of education doesn't need to be given to the client at all, and this is across India globally. So I think with that, in terms of us as lawyers spending time in explaining ground legalities, at least sort of that time has significantly come down.
Sure. So, and as I said, it's an amoeba which is trying to take a definite shape, disputes. So the effort that you are seeing from the government, Nitesh, what's your take on the Mediation Act?
So I personally believe that mediation is going to be the game changer when it comes to resolving disputes, right? Court, of course, is not the solution. We have seen the pendency of cases and the time it takes, right? Of course, arbitration is where parties are not able to resolve their disputes. Somehow you have to resolve it, right? But I think the various advantages of mediation, right? And thankfully, the government, because of the Singapore Convention, right? Finally, we have a domestic act now and the biggest advantage of mediation now is that the settlement agreement arising out of mediation now will be treated as a decree of the court, right? Which is where I think the key lies, right? So you don't have to, so Singapore of course has ARB made ARB, right? You start arbitration, mediation, and then convert that into an award, and therefore you have a consent decree, right? I mean, that's not required anymore, right? I think in any dispute, if you have a mediation clause which is mandatory, which I think it should be now according to me, and the Act clearly defines in terms of which matters can be referred for mediation, what are the grounds of challenges, and it's very, very interesting to see the grounds, right? They're very, very minimal. It's on fraud, corruption, very, very minimal. So you do away with 34, 37, all those grounds, right? Because it's a decree of the court, you straight away go and challenge if there is any dispute. The other advantage of mediation is that the parties are sitting across, commercially applying their mind and resolving and finding a solution, which is actually what the parties always intend to, right? All these legal issues in relation to seat, whether it's management, whether it's arbitrable, not arbitrable, whether we should do it enforceable, not enforceable, I think all those, the major legal hurdles can easily go away if parties are actually very serious in resolving issues. And therefore, the government's attempt of actually making this as an act, according to me, will be very, very helpful. Internationally also, India has signed it. It has to be ratified. But because now we have the domestic act, now it will help us. But this can happen only, of course, if you have that mandatory clause in the arbitration clause, right? Luckily, the definition of mediation in our act also includes conciliation, right? Because in a lot of the arbitration clauses, it says conciliation, but I think because of the act, the conciliation will also be included in the mediation. So that's how the catch point is. But of course, at the end of the day, it all depends whether the parties are willing to resolve by way of mediation or not, which is why there is also there is a time period provided, which is 180 days, which can further be extended by 60 days. And there is also a mechanism that if you fail after 2 attempts, right, then you don't have to continue. You can just straight away go and start the next steps, right? So I think it's a welcome step. It will save cost. It will save time. It will save a lot of disclosure, right? What we face in the arbitration, right? If you are able to resolve it commercially, nothing like it. Because at the end of the day, even after getting an arbitration award, when you are at the enforcement stage, you end up settling and negotiating and commercially resolving the issue, right? Which I think you can achieve by way of mediation. So, to my mind, I think, and that's where the role of GC, I think, I mean, just to stay on the topic, I think, if, in every clause, the GCs ensure that, yes, mediation is there as a pre-arbitration step, right? I think it can resolve a lot of these disputes.
So now let's see how good is the pudding, right? So let's ask the proof of the pudding. Zarina, what are your views? What's absolutely necessary for a successful mediation? In my view, is an environment where people are able to discuss the strengths and weaknesses of their case without any apprehension. So Zarina, does the pudding, I mean, is it delivered?
I'm guessing you're asking only in terms of confidentiality, but
No, across.
So I think one thing I want to answer, Nitesh, I agree with you that mediation should be written in. That would be good practice, good contract writing. But even if it's not written in, there is nothing to bar 2 parties from sitting across the table and mediating at any given stage. Whether the arbitration started or it's ended, it doesn't matter. Mediation can be a part of your process no matter when. You do not need to shut that door. If you choose to shut that door, of course you have strategic requirements or you have some plan or mitigation or whatever it is in place. But that door doesn't shut merely because it's written or not written into a contract. As regards actually talking and hoping that the dispute resolves across the table, you need a couple of things, a couple of ingredients to this pudding, as you would say. You need 2 like-minded people, or at least some like-minded people who are on both sides of the table willing to talk about settlement, who are willing to discuss that, yes, there is a dispute. Maybe it's not arisen only due to my fault or only due to your fault. Let's see if we can find a way to meet midpoint or closer to some point. If there is no impetus, if there is no desire on one side of the table, no matter how hard this side works, it's not going to happen. So no pudding is ever going to form in that case. So it really takes 2 to form this. And that dance will be incomplete if it doesn't happen that way. In terms of confidentiality, in terms of them having a sort of safe space, yes, I completely agree. That is something that is essential, where they can talk about it, saying that, yeah, I know it was my fault. They're going to say that I'm not going to be able to take it out of this room, or I'm not going to be able to prove it outside this room. But maybe because it was my fault here at this table, at this juncture, yes, maybe we can talk about a settlement or a number that's more reasonable here without arbitration. So yes, that is something that would be a great benefit to mediation also. And I would also say that in mediation, like you mentioned, it takes away all the complexities. It takes away legal dispute. I mean, the various challenges, the fraud. It takes away things that external counsel might bring in to try and impede or perhaps expedite the arbitration. It just allows 2 parties normally, without that dispute resolution, without that arbitration process, to talk maybe as friends and try and see if they can resolve it. So that is a great first step. But there is a lot of work to be done. It is only a first step. I think there are a lot of other things that have to change in our law for mediation to go as far as we want it to go. Maybe take it to a point where, I'm not saying it would take away arbitration altogether, but at least bring it close enough to that.
So obviously, and Ankoosh spoke about, so you spoke about family disputes, and that's how, as all of us know, the Indian law is that if there is a family settlement agreement, which very often would be result of whether you call it mediation, conciliation, intervention, that's semantics. If there is ambiguity, even then all efforts should be made to enforce it. So before I come to you, Ankush, Nidhi, do you think the GC's involvement in the mediation talks, especially to draft non-binding documents, etc., does that assist the process? And I'm going to come back to you, Ankush.
Before I answer that question, I'm going to add to what Zarina just said right now. As she correctly said, it's the intention of the parties which matters the most when it comes to mediation. Now, I have in my experience as a mediator and mediating on matters as well, I've observed and attended some matters of mediation in the US. It doesn't matter if you are a large conglomerate, and one of them was a large conglomerate against one of his ex-employee. The large conglomerate did not wait for the employee or the ex-employee to come down, on his knees and wait till the ego is broken and then bring him to the table. He was completely in the wrong. And me being, with the mediator, while I was with the mediator, I heard the witness, the evidence the company had against the ex-employee. But they still chose to settle the matter. I find that ingredient missing most of the times with Indian conglomerates, with all due respect. It's also because if I were, we still come from that perspective that if I'm saying more than I should be, then there's something wrong. Dal mein kuch kala hai. If we evaluate from every perspective and realize that maybe I'm just doing this in the spirit of mediation and just to get done with the matter, so that everyone can go home and, not live on bad blood, that needs to be developed in our thought process very, very importantly. So intention is extremely important as far as mediation is concerned, in my opinion. As to answer Rajendra's question, yes, I think GCs should be involved with everything that's been drafted and not being drafted. No, as in-house, no, for day-to-day work, as an in-house counsel, I generally make it a practice that there is a brain. One of the most important thing is you break walls in your talk, you break ice in your talking to your business teams on day-to-day basis, or you have a nice camaraderie with them, because they should be able to approach you when they have an issue, or you should be able to talk to them without intimidating them that what are you doing is wrong. And we hence ensure that every email which might be crucial goes through the lawyer's table if it's required. The purchase orders or the documents, most of the documents in the company, like NDA or purchase orders, etc., are standardized, which will require mandatory reviewing before signing off, but that reviewing will become minimal. So we would have the GCs involved because for us to work with the business team is extremely important. A lot of them shy away, to bring them on the table to even disclose, because they're generally in the defensive side saying that we have not done something wrong, because they think we're going to hold them hostage for whatever reason, and that's not the case. So GC's involvement, I think, is extremely important to explain the business teams as how it goes and take it from there.
So I think the first inning is over. So before we start the second inning, any questions? Because we are at the halfway mark. Yeah, I've got a question here. I've got a question. So why don't we start with you? We're going to give her a microphone, or is she going to? Oh, I can hear you very clearly, yeah.
I'm Professor Aditi Prasad. I'm currently teaching at India ADR. At the same time, I'm also doing a PhD on MSME dispute resolution from Xavier Business School. My question in general to you all is that post-pandemic inflection, there is an overarching shift towards the espousal of technology, which has created a wide space for online dispute resolution, which not only hints or verily prods upon dispute resolution, it also does talk about dispute containment. So my question is, how has that metamorphed your dispute resolution, specifically clause, arbitration clause, over a period of years? And at the same time, if there is a concept, I was not aware of midnight clause, which is signed, do you have a predetermined, identified policy for industry-specific disputes? Do you have something predetermined kept in your mind?
Nitesh, you want to take that?
Yeah.
If clauses come last
So,
moment.
SEBI came up, I think last month, they came up with their own arbitration rules, right? In terms of, I mean, a lot of disputes used to be referred to scores, right? They have come up with their own system in terms of how the disputes in relation to SEBI matter will be resolved by way of an arbitration. They have their own rules that includes technology to a large extent, right? So you have a specialized regulator dealing with this. A lot of institutions are now coming up with their own rules in relation to technology. But I think technology, I mean, it is sort of an essential part of any dispute resolution mechanism. So even if it's not there in the rules, right, I think the understanding is even if the arbitral tribunal is there, if it's only a procedural hearing, if it's a CMC has to happen, right, you don't need to do a physical hearing. They can be a, they can be a virtual hearing. If you're recording evidence, you know there is difficulty as far as that witness is concerned, right? I think it's all, there is an understanding that some lawyer can go with that person and there can be technology around to take care of everything. So I think technology is sort of inbuilt in the process, already. But a lot of institutions are, putting rules in relation to arbitration. A lot of courts have, of course, they have come up with their own guidelines, and so are the arbitration institutions.
But is India still far from something like cyber settle, which happens, which is nothing but settling out your options with respect to going into dispute at the very first instance? Do we still have something like that in India for dispute containment?
Not
is
something that I'm
basically-
aware of.
Yeah.
No.
Cyber settle is basically a dispute containment mechanism wherein online...
No, I understand the concept, but what I'm saying is I'm not sure if there's something in India.
Okay.
Sorry, can we move to the next question because, you want to shout or you want to wait for a microphone?
Good evening. My question is for the anyone from the panel can answer. Is in respect of Section 12A of a Commercial Act makes mediations mandatory. Correct. Now, after this mediations bill which has passed, where mediations has become optional, so what will be the situations of a mediations if the clause is there in an agreement?
So obviously 12A will prevail because it's a specific clause that deals with Commercial Courts Act.
No, but mediation act has came and now
But it doesn't matter because 12A will
No,
still
but
prevail.
then what will happen, sir? Basically, in case if the act says that it is optional, and if the earlier 12A of Commercial Act says, as per the Supreme Court directions, that it is mandatory, then there will be an inconsistency.
No. So therefore, in my view, 12A will still prevail. So that's the way I look at it. So to kind of ease this into now the third bucket, as I call it, that we've had an arbitration clause which is not pathological. We've had whatever alternate dispute resolution that we've tried, and now the arbitration is starting. So let's have two perspectives, and let's first start with the industry perspective, if I may call it, on how do we make it more efficient. So what are the points that cross your mind in terms of who should be your arbitrator? Should you go to which council? What else can you do in terms of use of technology to ensure that you can save money, because nobody likes spending money on a dispute. So why don't we start with Zarina and Nidhi, and then I'm going to go to the two council.
So disputes here, right? So I think the first question is, what is the dispute? What is the nature of the dispute? What are the numbers involved? What are the types of claims involved? If we have to do at least a basic evaluation of those. If we find that there is a significant claim or that we need to fill a hole there, do we need to bring in experts to determine the validity of our claims? Do we need to bring in a lawyer to even assess whether from our contract perspective, from our construction or from our expert perspective, will these claims be able to hold up in the court, in an arbitration, in a court, wherever? So the first part is definitely evaluation with your commercial team, evaluation with external maybe experts, and maybe some counsel help as well. So we would definitely take that into play before we decide that yes, we are going to file a notice of arbitration or take it forward from there. The second thing we will definitely need to do is to see whether our claims have enough backup, enough evidence to support it. Do they have a contractual validity from where we're going to bring them? Do we have enough documentation and evidence that this claim will be substantiated in the process? I mean, bringing a claim is easy enough. We have to look at it from the other side. Are there going to be big enough holes where they punch through and we have no claim left? So we've spent all this money on a claim that we believe that we should have got, but it will not be substantiated in law. So all of these have to go through a review process. They have to be analyzed. There has to be a risk analysis process of all of this. Documentation, as you know, in India has been a little lax. All of us, I think, are working on getting those processes in place. That is, I mean, a lot of times my external counsel will come and say, where is this memorandum? Where is this letter so-and-so, so-and-so? We needed to substantiate this. This is the best part of our claim. And I will not be able to show them this. So those processes, we are working on them. They are coming into play. We are getting better at it. But there is still some work to be done in that case also. The next part of the arbitration would, of course, then, depending on the kind of disputes we have, we've got to go into selecting arbitrators. We will, of course, sit with our counsel and see, you know, who would be the right person. It's quite an art. It's not a science where we'll say, here are the buckets, here are the points, and now we will discuss and we will select. It doesn't work like that. It has a lot of complexity. It has also, in terms of where they've decided, what they've decided, in terms of what the arbitrators themselves feel. So none of these are easy enough. And then when you do all of these evaluations, do we see merit in going for a whole arbitration itself? And again, like we said with Nidhi, with Nitesh, is there a possibility to mediate and just try and figure out if we can settle it? We always do try, no matter at what stage. That is what I feel that we have to actually start with. Then I'm going to let you go on with the next process.
We have our own ARB-Med-ARB setup. We will start our arbitration at any point in time. We lead to mediation and close it through consent terms if we want to. Like I said, that's why, you know, intention is the most important point. When I have an arbitration on its way, you know, as Zarina said, I echo what she said, and you know, the industry expert. It'll be great to have an arbitrator or a learned, you know, lawyer who's turned into an arbitrator from that industry experience, because every domain has its own, you know, issues, and as you also said about, you know, the industries where you come from, you know, that matters a lot, because there's a practice which is followed. And that practice has to be also taken into consideration while you take care of the procedural laws of arbitration, while you take care of the laws of the seat, etc. One of my, you know, concerns would be enforcement when I know the seat is different, the venue is different, the governing law, you know, of course, if hoping that there's not a separate implied or a different now governing law for the arbitration agreement itself. So I would, of course, be concerned about the enforcement of how, you know, I would discuss this with my external counsel as to where is it going from the enforcement perspective. How do we think it's going to work in our favor or not? The interpretations of some, you know, particular clauses as may be required, which is a subject dispute of the matter. Legal opinion on some particular issues that may be required before we start off, you know, because, and that I would start off much before my pleadings are on, because once you've identified your facts, you've got your documents in place, and, you know, companies nowadays are very well efficient, and we have a data management system, everything is in place. Documents are preferably standardized as much as possible, but, you know, still, if there are lacunas, that's how we have disputes. One more thing I'd keep in mind, apart from the arbitrator and my counsel being an expert in that industry, is how progressive is their thought process. Are they tech savvy? You know, it's important that they can deal with that, because ultimately it all comes down to my cost as well. And I have to constantly think about how my management is going to, how I am saving my management a buck. Maybe they can put that money into better use eventually, but that is an important aspect, and that works a lot, you know, in favor of GCs also. Not from just the money perspective, that because they know they are, of course, they want to win every litigation. It may not be practical, but you need to give them practical, wins as well, in as far as we're evolving through the litigation as well. So the practicality, I mean, I've had matters where my arbitrators have been so practical, and they're like, no, we'll just do an online hearing. Even if it was not there in the arbitration clause, they said, no, these all issues can be dealt with online. I don't want you all coming here. We'll finish this. And then only crucial hearings were taken offline. So these are the clauses these are the points I take care of as far as preparations are concerned.
Great, Nidhi. I'm sure after the session, you're going to have a long queue of people asking you for this list of arbitrators who are willing to, cut costs. But this is one perspective. Now let's just reverse the perspective. I know Ankoosh was making a point which I forgot to come to you earlier. But why don't you say, from a counsel's perspective, here is a client who says we want to start arbitration, and this is our level of preparedness. Where do you think it could be more efficient? What are your recommendations? What are your standard checkpoints, if I may call it?
No, I think there has to be a complete alignment between what the GC and the legal counsel are thinking. I think that outcome has to be common. You cannot be pulling in different directions to say, no, this is what you will get. And I think the time of, being, not being completely candid about where your case stands, I think those days are gone. Because the question of, or the level of accountability that exists today is way too much. So where I see this standing is that, we expect that, general counsels like the two ladies on my left, I mean, they would, or their organizations would definitely first ask for an analysis of really what are the strengths or weaknesses in our case or in our defense. I don't think any of these organizations of that level or anyone is going to move ahead without that. And, thereafter, I think there's going to be a call taken internally in terms of, whether this should be, this claim should be, taken ahead, this claim should be dropped. And, at the end of the day, it's going to be a number that is sitting on the balance sheet, whether this is worth it or not. So I think that's definitely a one big call, and we see a lot of deliberation, before a green signal is given that, okay, go ahead and take this forward, etc., etc. So I just want to limit it to that. I think before the actual arbitration begins, I think the level of internal consideration is just way too much, and that's why I feel the GC's job is extremely tough, because they are completely sandwiched between the management's expectation and the realities of court.
Ankush, thanks a lot for echoing that. I'm really happy to hear that from a lawyer. Think seriously. But I'll just add to what Ankush said. In addition to the GC and the external counsels being on the same page, it's also important you have the business teams on the same page. Like I said, a lot of times they just shy away from giving you information. I might have a claim. We've had these incidents where, I have a $1 million claim against a company who's connected to some royal family in some jurisdiction, and I would not know that information. I would not know if I'm going to be roping them in for my future contracts. I do not know what's the value they add. So before I go head on fighting with them, I would want my business team or my management to inform me that how do I want to deal with them and where exactly was the problem. Because they are the people who are on ground reality, taking day-to-day correspondence, discussing, their tonality might have irked someone. You have to keep these things in mind, and that's why having them, and it's, believe me when I say this, if you think two lawyers discussing is difficult, try discussing with a business team. Any department, HR or professional, the operations team or the IT team, they will not open their mouth and discuss anything because they think you're going to hold them ransom for something or the other. So to break that ice and make them talk is a task in itself, and all three of them should always be in the same page.
So I think that's where I think an outside counsel helps, because my experience always is that when the outside counsel says that, put your signature on this, and know that if suddenly something comes up and blows in your face, then don't look at me.
Yes.
And I think that is often an easy answer. But so Nitesh, if you could just briefly tell us, what else would you think of Here comes an arbitration, tribunal appointed, and client says, how do we make this more efficient?
Yeah, so I think there are various quick steps, right, which should be followed as a matter of protocol if an arbitration has been commenced, right? Of course, you've identified the correct, your nominee and the tribunal, right? If there is any sector specific, you have that specialized tribunal, right? So that on technical points, somebody's there to understand that, right? There is a detailed fact finding that has to start already in parallel, right? Before even you get the procedural order, and there are timelines for statement of claim and defense, right? So that fact finding has to happen. You need to have experts already, whether you need fact expert, do you have witnesses, do you need external experts? And I think their role in deciding your response to notice of arbitration or notice of arbitration, heads of claim, it has to happen at that stage. It's very important to see what all evidence documents that you have, whether you have the ability to claim privilege on those documents. The law of privilege works differently for different jurisdiction, right? For common law, of course, the correspondence that in-house has internally, right? In UK, Singapore, US, you can claim privilege. In India, because of the Advocates Act and the Bar Council rules, you can't claim privilege, right? While you start preparing, and if you have an expert, you have to be very careful whether the work product that's happening is for the purpose of litigation, so that you can start documentation, your engagement, and qualify that everything is for the purpose of litigation, and therefore you can claim privilege, because you know in discovery somebody is going to ask, and therefore you should start doing that. You may in parallel also, if you think you have a good case, start identifying maybe the assets, right, of the counterparty, that if you have an award after 18 months, right, then do you need to go in parallel or along with the arbitration emergency, do you need to get section 9, do you need to have some sort of a security, right, for the purpose of enforcement. So I think there are various steps that you need as a part of preparation that you need to follow, whether it's external people, consultants, engagement. You have to think, on all fronts.
So while you're holding the microphone, Nitesh, let me ask you this. So now let's go into the final bucket. Yeah, you've done your prep. So what I did in a BIT is at the first hearing, I went with a memorial. So when the tribunal said, let's now define the timelines, I said, no, here is my memorial. So let's talk about the reply memorial. It depends on how aggressive do you want to be. Are you okay with your costs being accelerated? Because when you draft a memorial before starting. But those are all strategic calls that you take. But now the arbitration is underway. So what do you think are precautions that parties can take in order to run an efficient process? And I know that, we have to kind of crunch everything into this 1 hour. And I had Nidhi coming and telling me, I don't know, I think it meant 9 minutes. But what are your views, Nitesh?
So to efficiently run any arbitration, right, irrespective of whether it's an institution ad hoc, whether you're doing it domestically in India, outside, right, I think that preparation has to start from day one, right? And I think some of the points I already covered in terms of the preparation, right? Is that I don't think you can wait for your procedural order to come, as you rightly said, and to see that, okay, the witness will come only after 6 months. I think you have to work backwards, because if you don't have a fact witness, if you don't have an expert, right, I think in your heads of claim you can't identify those issues, right? So I think arbitration is all about forward thinking from day one, right? And which is where I think the issues of privilege, document discovery, all those things come, because just to see what is that you have in order to go aggressive or to be defensive, right? If you don't have, and you will end up disclosing a lot of, your cards, right? Then, as Nidhi rightly said, that you might as well just go and settle, right? So I think it's the reality check, according to me, from day one that identifies the efficiency of an arbitration. I'm cutting my answer short, keeping in view of the time.
Thank you, I really appreciate it. So, and again, just to add my 2 bits before I go to Ankush is, what I have learned, and I actually intend to put it on my CV that I've done 3 Bombay High Court trials. Because if you ask a Bombay High Court counsel how many trials have you done, they say we are Exhibit 5 lawyers. But one of the first things which a very senior advocate in the Bombay High Court told me is that when you draft a plaint, the temptation to add adjectives is what you should resist, because remember, the monkey is going to sit on your back when the matter goes to trial. So, and that's what I would say, as I said about an arbitration clause, I would say that about a pleading, I would say that about procedural order. The less you say, the less is the chance that there'll be complications. But your views, Ankoosh?
So I'll keep it short. I'll just say 2 things. One is just the person at the chair, the arbitrator, I think he needs to be tough and firm and not give indulgences. And secondly, conciseness in approach, whether it's pleadings, whether it is, affidavits, etc. I think these 2 things, should sort of reduce the delay, according to me.
So, sorry, yeah, exactly, because I thought it was 8 minutes and suddenly Honey, I Shrunk the Kids has happened. So, do you want to go first, Nidhi?
Sorry, what was the question?
So the question is, during the arbitration, in your experience, what can make it more efficient?
Identifying the witnesses beforehand and preparing them, for the avalanche that's going to be thrown towards them. Because I can prepare 10 witnesses who might turn up on the last day is my luck. They'll find 10 different reasons, and we cannot impose upon them that you have to, be my witness in the matter. And like I said, discussing the business prospects again with the companies, etc., and the future with those industries is important. So discovery of documents is, your evidences, your documents which you want to disclose, etc., the preparing of the witnesses, I think these are the most important points in housekeeping. And your document, a lot of times we the business teams clearly do not keep a lot of documents with them they think are not important, which we might consider are important. So you literally have to go through each and every document, morsel of a document, to ensure if it's really adding to your matter or going against it. So yeah, the housekeeping work increases for us as GCs by and large with that.
And I echo everything you said. I just think that you need to do your asset tracing. If you're going to go in for an arbitration where at the end of the day they're going to say that, oh, it was an SPV, we got no assets, maybe you need to cut your losses at that point in time. So I think that will also make it more efficient from your standpoint and from cost there.
Thank you very much. So just to, so I think we've got a couple of minutes left, although here it says time's up. Any questions that we can answer in a couple of minutes? Okay, that's great. So in summary, as all things keep evolving, I think change undoubtedly is the only constant. And all of us keep learning. So hopefully, nobody should say that what we learn from history is that we don't learn from history. Thank you very much.